May it please the Court, Arthur England on behalf of the Kelly family. I'd like to reserve 5 minutes, please. Location, location, location. Those are words, everyday use, that denote real property. Your Honors, those are the words that Mattie Kelly used in Article 8 of her will. Here, here, and here. This is an appeal which asks the Court to apply what can only be called Will Construction Principles 101. Wills must be interpreted to carry out the intent of the decedent expressed in the will, giving words their plain and ordinary meaning. Wills must be construed as a whole. Taking the text from your decision, if you will, in Diana versus Benson, from the first letter to the last period, which of course then requires that Article 8 be considered in the light of Article 7, which says that a mausoleum is to be built on the property, compatible and to coexist with the goals and purposes of the gift of her residence and surrounding property. And in conjunction with Article 6, which gives $1 million for music scholarships to 4 state universities other than this community college. And the third principle, of course, you're familiar with, that no extrinsic evidence can be considered when the will is clear and unambiguous. Your Honors, it's our position that that is clear and unambiguous. And I asked you to apply the 3 principles I just mentioned in a very, very easy way. If there had been no testimony from Dr. Richburg or Mr. Perry saying that Mrs. Kelly had spoken to them and had acknowledged that if the property had to be sold because the purposes of the Institute could not be carried out, that was okay. And if Dr. Richburg's proposal to Mattie Kelly had never been in evidence, but if there was admissible and undisputed evidence from Dr. Richburg that Mrs. Kelly's goals, as expressed there, had in fact been carried out in her residence on this property for more than 7 years, would you have any doubt whatsoever that Article 8 is clear and unambiguous in directing, number 1, that the Mattie Kelly Institute was to be situated on her homestead property, number 2, that the goals specified in her will, those 4 identified there, for which she gave the college $500,000 to maintain and operate the Institute in conjunction with her mausoleum, and that in light of her gift of music scholarships to other institutions, no part of that bequest was to be intended for the community college, would you have any doubt whatsoever that that language was clear and unambiguous in what it conveyed? I think not.
Mr. England, did your clients object in the trial court to the presentation of extrinsic evidence?
Absolutely, Your Honor. We moved for summary judgment on the basis
But did they object after summary judgment was denied? Did they object to the presentation of the testimony of the lawyer who drafted the will and the president of the community college?
Your Honor, after the judge said, we're not going to have summary judgment, you're going to have an evidentiary hearing, the question came up, who's going to testify? The lawyer, I believe by statute, was allowed to testify. And I believe there was an objection, but then an acknowledgement that Dr. Richburg had no interest in it because he was a part of the college as opposed to the foundation, which was the party, so that the dead man statute did not apply. That was not the case with respect to our clients who had an interest in the dead man.
I wasn't concerned about the dead man statute particularly. I was concerned about whether the issue of whether the trial court should have considered extrinsic evidence at all was preserved.
Oh, that was, Your Honor. That was the whole point of the lower court proceeding up to the time that the hearing took place. Your Honor, it's a very simple case. There is no authorization in Mrs. Kelly's will to sell the homestead property. There is no authorization in her will to divert her bequest from those identified purposes to unspecified purposes that the college faculty has decided it wants to institute.
So is it your position that the will and the deed giving effect to the will created a trust?
No, Your Honor. No, this was an outright gift of property for specific purposes, which they acknowledge.
All right, so is it your position that the gift failed?
Pardon me?
Did the gift fail?
No, the gift did not fail. It was being carried on for 7 years. They wanted to change the gift. The question is whether, given that it was an outright gift for specific purposes which could be carried out, were being carried out, and can continue, and that's the testimony, to be carried out, the question is, do they have the authority, does the will give them the power to change the purposes and to move the facility from where it was supposed to be, quote, located, unquote? And the answer was no.
Mr. England, let me ask you about the impact of the deed from the personal representative to the community college, if any. I assume this was a warranty deed?
I assume so, Your Honor.
Did it include any reversionary clauses?
No, Your Honor. It referenced the will, but I think I'm going to answer your question by saying that this is a red herring. The deed has no relevance. This is a will construction case. The question is what Article 8 of the will means. It has nothing to do with what the personal representatives might have done in trying to carry it out, and where they specifically incorporated by reference the terms and conditions of the will.
So your position then, I take it, is that by virtue of the will, your clients are entitled to seek, I guess, an injunction prohibiting the community college from using the property for any other purpose than what you believe the will provides, notwithstanding that the deed doesn't include any restrictions.
Absolutely, Your Honor. We're not construing the deed. This has to do with the will.
And what happens to the gift when it becomes an impossibility for the community college to use it for the purposes specified in the will?
When and if that happens, they can come into a court of law and ask for the doctrine of Cypre to be applied. But that's not what they did. They came in and testified it is possible, it is going on, and, according to Dr. Richburg, can continue to go on exactly as it has and according to those specifications. That would be a different case. This is nothing.
We're one more legal proceeding away from doing what the college is doing now.
Well, it's going to be hard-pressed for them to bring that other legal proceeding when they've testified and they've established that this is going on, that the exact purposes are being carried on in her residence now, except for a little inconvenience of mud in the parking lot, which they have to get around. Mattie Kelly gave $500,000 to maintain this property, which has grown to $1.5 million.
Yes, but tomorrow they could determine that it was an impossibility because in order to carry on this kind of institute, a different facility has to be provided, in which case this wouldn't work.
Yeah, Your
then
Honor,
they're one legal proceeding away from doing exactly what they're doing now.
When they come back with that leading proceeding, I'll come back and we'll talk about whether they are doing something that the doctrine of Cypre authorizes. But Cypre is not an issue in this case because there is no impossibility. I don't believe they suggest it is.
Well, we skipped over a preliminary issue, that of standing.
I want to talk about standing only to say it's really pretty well set out in our brief, except I'll note for the court, the foundation doesn't challenge the ruling of the trial judge twice that the party has standing under the Mingledorf case, under your decision, if you will, in, I want to say Eastern. I've forgotten the name of the case for the moment. But they don't challenge the standing on the two rulings the judge made, and by the way, they didn't cross appeal any dispute as to those rulings. What they're saying is that, and I don't know any law on this, and I don't believe they have cited any authority for it, that a party with standing can be ousted mid-trial by a unilateral act of the defendant. A plaintiff can be ousted of standing by a unilateral act of defendant based on a document which is executed between them and somebody else. But there's no such principle of law, and that's what their argument is. We don't have a problem with standing. They didn't have it to start with, and it doesn't exist at all. Neither did the trial judge, of course, after he got through it.
Mr.
Your Honors, there's one other point.
Let me ask you again, I'd like to get back to Article 8. You say it's unambiguous. It can only be read one way. Why can't it be read, and I agree it can be read the way you argue it can, but why can't it also be read as saying simply, I'm giving real and personal property of X value for the purpose of creating the Maddie M. Kelly Cultural and Environmental Institute, which institute is to provide an arena, if you will, for certain types of activities, and that arena can be provided anywhere the community college wants to provide it.
There are two answers to that, Your Honor.
What it says is, the first part of what you said is correct. I'm creating an institute. And the purpose of it, she wouldn't have said to provide a meeting place here. She would have said to have literary societies and fine arts groups available to college, or to provide conferences and seminars on the county or on ocean studies. But she did say it was a meeting place and it was a location.
But see, I have to confess, that intent is not as clear to me from that language as apparently it is to you.
And let me go to the second part of the argument about that. Because taking the principle that wills are construed as a whole, you've got Article 7. And Article 7 could not be more specific
With respect to this point, where it says that she directs a home to be built on the site of the grounds surrounding my home, and then down at the bottom, will be compatible and coexist with the goals and purposes
It directs
of
a
my
mausoleum to be built.
Pardon me?
Article 7 directs that a mausoleum be built.
Yes, that's the mausoleum. On the property, which is, and this is her words, in Article 7, immediately before Article 8, quote, compatible and coexist with the goals and purposes of my gift of my residence and surrounding grounds, unquote. Judge Webster, I have yet to hear from the foundation how the mausoleum inside a gated community of residential homes on 1200 in this Destin area can be compatible with and coexist with the activities they're going to create in Niceville across the bay inland at their college campus.
Let me
You
ask you,
cannot separate this from Article 7, Your Honor.
Is this parcel on Choctawhatchee Bay,
Yes, it is, Your Honor.
but not on the Gulf of Mexico?
That's correct. It's on the inside. That's correct. I think I put two maps inside the brief for that purpose.
All right, so when you talk about a location for biology studies and marine science studies, is the marine science studies are to take place at some distance from the Gulf of Mexico, however you read Article 8.
Yes, but this parcel of land is a peninsula. It's surrounded on three sides by water. Remember, she considered it inspirational. It was very unique. There aren't that many more in Destin, and that's where the processes can be carried on for the marine studies, the biological studies, not in the center of a city, which is remote from both the bay and the Gulf.
I have to tell you, it's the first time I've ever heard Niceville called a city.
I'm giving it more credit, perhaps, than it's due. I don't know the area particularly. I know where it is in relation to this, and it's nowhere near it.
Niceville used to be a place where we went and played in the woods. You drive through now, and it's just all built up, so maybe it is.
Well, Your Honor, I think probably Destin, you remember also as a pretty small town. Anyhow, that's my argument. I'd like to save the rest of my time for rebuttal.
May it please the Court, Your Honor. My name is Bruce Culpepper. I'm joined by Lamar Connerly as my co-counsel. We represent the College Foundation. The two central issues, I believe, for the Court today have to do with the lack of standing, which was addressed earlier and which I'll spend some time with, and the purposes of the Kelly Institute. I'm going to go right to Article 8, if I may. Mrs. Kelly wanted to contribute to arts and sciences, so she bequeathed her land to the college to establish a foundation. And then, in turn, there was a personal representative deed, a warranty deed, to the college, which said that and only referenced Article 8 in the deed, and said that the deed was according to and for the purposes set forth, stated in Article 8. The college thought at the time that this was clear in terms of the mandate to the college. The College Foundation has the responsibility of doing what it is that they believe that Maddie Kelly intended. And so when the college read Article 8, this is what the college saw. First, that the purpose of Article 8 was to establish an institute. An institute meant to the college more than simply a caretaker for a residence. But an institute, by definition and so forth, is an organization that supports and develops and creates a particular discipline, whether it's arts, sciences, or whatever. So she created, and that was the purpose of Article 8. You will see nowhere in Article 8, Your Honor, where there says that it is to be located, the institute is to be located on her property. There's no such words.
But isn't that a fair inference from the gift or the direction to build a mausoleum?
That's in Article 8:7, which isn't referenced in the deed, but nevertheless, I want to address that, and I have a copy of it, and I'll explain that in just a minute, Your Honor. Exactly. No, it's consistent. When you look at Article 7 and Article 8 together, they are consistent. Let me finish my thought with this now. It was to create the institute. It says to provide a, not the, meeting place, but a meeting place, these are the purposes of the institute. And then she left funds, which she said for operating costs in furtherance of the above purposes. In furtherance of the above purposes. And when the college reviewed that, they believed, number one, in furtherance of the above purposes, indicated that the use of the funds was to expand, promote, and support these particular activities that she's listed in her purposes, which have to do with fine arts, performing arts, environmental services, for the entire Gulf, as was the question from Your Honor. Now, if you go to the will and you read Article 7, Article 7 is the first time that the college is mentioned in her will. Article 7 gives the college a significant responsibility and personal to her. Mrs. Kelly says the college, because I am giving my residence and surrounding area to the college, I want the college to participate in the selection of a location for my mausoleum. Work with the personal representative, and that was done. And then she said at the bottom, because Article 8 was to follow, of course, where she was going to assign what the balance of the property was to be used for, the purposes of the balance of the property. Two uses. I want to be buried somewhere on that land. Thereafter, I want the balance of it to be used for the establishment of an institute. And so she used the terms, I want to coexist, or I want it not to conflict, in effect. I do not want my direction to be buried on the land, to conflict with or to prohibit my gift, because Article 7 says I want it to coexist or be compatible with my gift, not with the residence or whatever, with my gift. And so what she has done is she is saying, I do not want to prohibit, this is our interpretation of that, I do not want to prohibit the use of the balance of the property for the establishment of an institute, which will be the Maddie Kelly Institute. Now, as I said, we thought that that was clear and, of course, entered a contract. When the appellants came and suggested that this was a very limited interpretation and that these purposes were specifically to direct the college foundation not to support, not to expand, not to continue these types of activities, but merely to operate a house, to reserve and preserve a house, and open that for particular meetings. When that came forward, the court then, correctly, which the court may do if there's any uncertainty, reserve the right with regards to making any determination for summary judgment beyond saying that I'm going to consider extrinsic evidence. because he was uncertain because of the two positions. And so at that point, the court then went into extrinsic evidence. There's been no reference to that from the appellate side, but I think the court knows that the extrinsic evidence was exceedingly strong and supports the position of the college that the institute was the main focus of Mrs. Kelly. And it was the institute that she was interested in leaving her legacy for promotion and development of the arts and culture environmental in her area.
All right, so you say there's a latent ambiguity, that once you say the house can be sold, then you have an ambiguity when you take into account Article 7.
I think the court, when it was presented to the court on summary judgment from both sides, believed that there was, he said it was not without ambiguity. And so then, therefore, looked to extrinsic evidence.
But the ambiguity only arises if you are talking about separating the parcel into subparcels, dividing it. In other words, if it all is going to remain there, then it's very clear about how you keep the mausoleum compatible with the...
I believe the sense of the trial court, Your Honor, was the ambiguity or the uncertainty that he wanted to delve into further with extrinsic evidence had to do with the purposes of the institute and whether the college foundation could sell or not. And the request was to enjoin the sale. And so he looked at the underlying issues, the will, Article 8, which is what was included in the deed to the college foundation, and said, the words are clear, as he said, which I understand that. The words are clear, but it is not without ambiguity. And
there are at least two possible ways you could read Article 8.
At least two or more. I think there are more, Your Honor. But there's certainly, the college, as I said from the start, believed that this was not a restrictive intent that was described in Article 8, which came with the will, but was more a direction to the college foundation to use, as she said, use the property to establish the institute and then to further support the institute or expend the funds in furtherance of the purposes of the institute. And the focus was on the institute. There are quotes in the...
It just seems to me that when you read this article and then you think in terms of the testimony of Dan Perry, who drafted the will, who may very well be, with this kind of size of an estate, a very accomplished lawyer over there, that if it were intended, there were any intention that this property was to be given to the school for purposes of use as or sale to provide money for use as, he simply would have said that and made it abundantly clear.
Well, what he did say was that any requirement that the institute remain on the land was excluded specifically, and that there was discussion with Mrs. Kelly as to the fact that this land may have to be sold. I mean, he specifically said she wanted the institute.
But how simple would it have been if that were the case for him to simply put that in the will?
Well, Your Honor, I believe both sides are maybe reading, it
would have been equally easy to put in the will, however, this property can't be sold.
He could have done that, yes. The answer is obviously.
That would have made it clear, too.
But what we're dealing with is Mrs. Kelly's intent, and so his explanation was that she wanted to exclude any prohibition on sale. Now, as we're surmising, Mrs. Kelly also could have picked, if she knew what the ultimate use of the property that she was giving to the college was to be at the time, she actually, or if she was really going to restrict it so that the house was going to remain there unsold, the institute was going to be there forever, and that was what her intent was. She could have also very easily have picked a location for her mausoleum, which was very important to her. But she did not know. And Mr. Perry actually explained that. He said when we drafted it, we weren't sure what was going to happen to the land. And we wanted to have the mausoleum located someplace that would be accessible to the family, but also separate from what was going to be developed on that property, whether it be an institute or whatever else. We just simply did not know. And so what she did was they created 7 and said, don't interfere then with my goal of establishing an institute. And then Article 8, which establishes the institute and leaves it to the college to develop.
Is there any reason why the college couldn't build the mausoleum and then sell the rest of the property for use as an amusement park?
That isn't the case, obviously. I don't know that there's a restriction for that.
In other words, the college could do that
I
under
think the college,
your view.
it's a fee simple deed to the college without reverter, without any lapse. There is no legal condition that would create a reverter with regards to the land, so it is owned by the college to be used by the college. And the college has a responsibility to use that in a manner that supports the institute, of course. So in terms of its choice of or to whom it could sell, that's not an appealing position, but I think it's within the discretion of the college. It was given outright to the college to make that discretion. Yes, Your Honor.
So what exactly is the restriction requiring compatibility between the mausoleum?
I think that has been met, because from the college's reading of Article 7, now recall Article 7 wasn't referenced in the deed. They have a deed and it references only 8. But the Article 7 says, put my mausoleum in a location so that it will be compatible with the establishment of an institute. And it is that. And it became that. It does not. It is located in a place that was picked actually by the personal representatives and the family, in a location that was called very, very lovely, a beautiful place, I think was the testimony. And it's off to the side from the balance of the property. So it did not conflict with the use of the property for the development of and establishment of an institute, which was the direction that came from Article 7. I want to talk just a moment in the amount of time I have left, or at least express comment about standing. The court reserved ruling on standing until the end, and although he heard initially and there was a specific motion from the College Foundation initially to dismiss for lack of standing, he reserved that because of the familial interest with regards to the mausoleum. And that was unsettled at the time that hearing went on. And so the court reserved that ruling until the end, and then ruled at the end, as you know, that the appellants did not have standing. There is no lapse here. The property has already been given. The estate is closed. The property was given in 97. There are no reverters. There are no provisions for reverters in the will. There are no provisions for a reverter in the deed. There is no condition that would require the property to come back into the estate to give a residuary interest to the appellants. They have no specific legal interest that is greater than the general public at this stage. Now, he
right,
said...
So if the college had never held the first meeting of a literary society or other such group, if the college had immediately sold the property to a third party, there would be no recourse.
To these appellants, if the mausoleum had been carved out so that the balance of the property was sold, so that under the Mingledorf case, the appellants would have no interest in the surrounding property, which, as you remember, was the Mingledorf case, then at that stage, the appellants would have no legally cognizable interest beyond what the general public would have. Now, under your scenario, if the personal representatives perhaps could raise a question or have some standing, I do not know. But that isn't the issue here, of course, and two-thirds of the personal representatives agreed with the sale, of course. But that was not, I mean, that hasn't occurred here, of course. But Your Honor, we believe that the court was correct, that there was, I see my time's up, that there is no standing. We did, with regards to the dead man statute, there were, or at least the testimony, the extrinsic testimony, there were no objections to the extrinsic testimony that was used. And I think the record shows that throughout. Thank you. Thank you.
Your Honors, I have 4 quick points, but I apologize for not having introduced trial counsel who were here at the council table with me, Mr. E. Allen Ramey and Lori Bytel, who came over to watch the argument and participate in preparing. Your Honor, 4 quick points. They're testifying to what the college thought this deed meant, but that's not the test. The test is the plain and ordinary language and what it means in common understanding. Their interpretation is to garner $8.1 million, not to carry out the purpose that anybody would have thought Articles 8, 7, and 6 together. Mrs.
The carving out the mausoleum property was a fallback position, right?
Oh, and yes, in mid-trial. And Your Honor, your question was an excellent one. What if it was an amusement park? Well, it is like an amusement park. It's a gated residential community. There's no difference. It has nothing to do with anything at the Institute. For counsel to say that the compatibility in Article 7 for the mausoleum is with the purposes of the Institute means that from this day forward, the gated people, the residential people, but nobody else except family members, will have any knowledge of what this mausoleum's before. Same thing with an amusement park. There is no compatibility with the Institute sitting here with the college activities in the Institute in Niceville. Judge Webster, you asked me, extrinsic evidence, was it okay? Maybe the answer is this. Take the alternative. We don't think this is correct, but if it was an ambiguous will and there was extrinsic evidence, what did it demonstrate? Not exactly what Mr. Culpepper said about she was okay with the sale. What it was undisputed from Dr. Richburg and the drafter of the will was that Mrs. Kelly's primary intention was to have the Institute operate on her property in Destin, and they both testified to this, that they would approve, that she might have approved a sale only if it was impossible to carry out those purposes. I've cited those on my initial brief on page 10.
But Mr. England, don't you have to concede that assuming the trial court correctly concluded there was a latent ambiguity and correctly heard extrinsic evidence, don't you have to concede that there's CSE for the conclusion it reached?
Your Honor, the test is whether, if there's testimony that's unrebutted, and we've cited to that in our standard of review without complaint by the other side, if it's unrebutted testimony, it's not a question of competent substantial evidence and can go either way. It's a question at least of the weight of the evidence according to the case law, including from this district, where it's unrebutted. And there is no dispute that her conversations with the drafter and Dr. Richburg were only if it was impossible to carry it out. And we know that is not the case because Dr. Richburg said we can carry it out and we can continue to. And that the purpose that she intended was it be there as her primary intention so long as it can be operated there. So you don't get this easy, we pass to the trial judge on passing of the evidence test. Let me conclude by saying this. We don't believe that this is ambiguous when you take Articles 6, 7, and 8 together. They express in plain language an intention by Maddie Kelly that the Institute's to be located on her homestead property, as she requested, not in Niceville, that the purposes enumerated in Article 8 were to be honored, not music scholarships and a professorship that she was giving to other institutions in large dollars rather than to this college, and that the institution was to be situated compatible with her mausoleum and her husband, Coleman. We respectfully suggest...
But the estate is closed. Your clients are 5% beneficiaries under the residuary clause.
Yes, Your Honor.
How can they wander in here at this point?
They didn't wander in here, Your Honor. They started this lawsuit. It was only when in the middle of the trial they came up with a gimmick of saying, oh, we'll give this property under the mausoleum back to the foundation. that leaves our people with the opportunity, if you will, to go to the entrance, could have been an amusement park, but it's a gated community, and say, we'd like to visit our family members, our mother and our father, who are deceased and are in the mausoleum. Would you please let us in? We don't have a number that you can ring to call to see if we're permitted. That's only for the residences. That's absurd. Of course they have a continuing interest under Mingledorff and common sense. Thank you, Your Honors. We request that you reverse this judgment and direct the institution of an injunction. Thank you.
Thank you very much. That concludes our cases for today. We'll be in recess.